a lot has been said about AI and patents. I'm not a patent practitioner myself. I'm a trademark practitioner. I'm one of the directors of a very small firm in South Africa based in Johannesburg. I run it with my partner, Madoda Kumalo. And I've been invited to come and, share some thoughts about, what I think insofar as protecting innovation across borders is concerned, insofar as it relates to trademarks. I'm not going to say a lot about copyright law stuff. Previous speakers addressed that in more details earlier on. I mean, there's a lot that you would want to, consider and look into when you talk about protecting, your trademarks, especially across borders, and bearing in mind that, systems differ from one country to another, from one continent to another. There's a number of, multilateral agreements and or arrangements, if you may, that inform how best you can protect your trademarks. And you would have to obviously have, to consider the full cycle of your trademark life when you do that, ranging from assisting clients in selection of their trademarks up to issuance of registration certificates. And I mean, after that comes also maintenance, comes ADRs, dispute resolutions, comes quite a number of other things that you may have to consider as you do that, such as licensing as well. Something that I thought I should also, touch on that sort of links to trademarks, and not a lot of people talk about it a lot, is domain names that as you get instructions from clients, to deal with their portfolio of trademarks, you also have to have a look into domain names, which, it's a totally different system, if you may, that also looks at how you can also register that, linking back to the trademarks that you are filing for protection under. And I mean, also with domain names, you would have systems that differ. I know with the US, for instance, there's ICANN, which would be dealing with such namespaces as your .coms. And when you go to other countries, there's your top-level domains, country codes. For South Africa, it would be your .za. I know with Ireland, it's IE and such things. So you would have to also make sure that as you run your searches insofar as trademarks are concerned, you also do the same with your domain name searches. So as you prosecute for registration of the trademarks, you also do the same with the domain names. You also attend to their renewals. And if there's any dispute resolution you need to deal with, you also do that. The question then becomes, how do you then, in getting this off the ground and rolling it out, navigate, this protection internationally? And my sense is, look, you really need to understand your client's business case, so you are able then to advise properly. You need to do some due diligence insofar as your client's business case is concerned, because I mean, at the end of the day, you'd have to sit down and decide, the classes that you would have to protect under in respect of the goods or services that your client is interested in, or they are already in that market providing those services or goods. You would need to understand the jurisdictions that are affected, that you'd want to have a look into when you protect such trademarks. You may even have to, have some relationships, be it locally, be it internationally, with other practitioners that are on the ground and that understand how the system works in respect of, respective jurisdictions. You need to understand how, internationally and locally, policies and laws and regulations of each and every country that you would want to protect and operate. We mentioned, well, not me, but there was mention earlier on by Jacob about the UK IPO office. These are again the sort of authorities that you would have to also understand as you do that when you focus in or on different jurisdictions. That for instance, if you are talking South African protection, then there is the commission, the Companies and Intellectual Property Commission, that you would have to file with. That's if you're not filing under, for instance, in Africa, let's say a repo, where there's an arrangement that if you file through that system, then you get protection in a number of countries. And essentially you would have to have a plan insofar as your implementation of that protection is concerned to the best that you are able to do so on behalf of your client. Generally, trademark rights are considered to be, distinct in each country and jurisdiction, and each country, depending on what their policies are and laws, they would want to recognize such rights insofar as they talk to their policies, and other considerations, perhaps social interventions and the like, and you would have arrangements where there are treaties that would allow you, in some instances, for you to file in one jurisdiction that also gives you protection in respect of other jurisdictions. So it really depends. And I mean, you would also have to have a look at how the system itself looks and how the system itself works, so you are able to then tap into those systems insofar as protect. I mean, for instance, we know with trademarks, just like any other international organizations, we have WIPO for intellectual property, which informs how the world systems work and how then we realize those objectives locally in respect of a number of countries. There are European Union trademark systems that if you are focusing, for instance, in Europe, you would have to understand how that system works. If you are looking into going into Africa, you would have to understand how a repo works. I'm not sure with the US what systems we have. There's also the Madrid system. There's the Paris Convention, the Indian Pact. And I mean, importantly, these agreements here, the Nice and Vienna agreements, are also very important as you consider your client's business case and how best to protect their marks, logos, slogan, that you would have to have a look into, so that you are able to classify their business accordingly, and you don't, fall into misfilings. But generally, you can register anywhere as long as your client is active in that space. You can register anywhere where your client looks to enter into, a particular market, and there are, arrangements, like I said earlier on, which would allow you to, maximize protection, only if you understand how they work. And I mean, where you're not sure, you are able to then, like I said, check with colleagues and consult and see how best you can then roll that out. Thank you.
So do we have any question from the audience side?
I have one. Just general question. You know how do you identify your country's law system? Is it belong to the group of civil law or you say the US law or the English law?
It's
The continental or just like Anglo-US law, American law?
look, we are mainly Roman Dutch in South Africa.
Yes.
And it depends again on the area that you are focusing on. Then it would differ from one system to another. For instance, I'm thinking now, our competition law, space. We follow more of the European system than we do the US system. But there are some learnings that we take from the US insofar as antitrust is concerned. When it comes to trademark law, I would assume we lean more towards the European, side of things, as opposed to the US. But be that as it may, we still apply these systems to the best of our abilities and to the extent it makes sense even for clients.
Yes. Well, my next question is actually related to our experience in China. Trademark is one thing. Meanwhile, you say we call the trade name, a company's name, also related to trademark. Sometimes, for example, some foreign companies, they come to China to do their business. And some Chinese companies or individuals just register that foreign company's name as a trademark in China. And then when the foreign companies found out that they want to have registered their trademark in China, they say, okay, you come too late because your name has been registered by some Chinese individuals as trademark in China. This is one situation. Sometimes they register a company using the similar, quite a famous trademark as a company's name. So based on Chinese law, I think in your country is the same. The trading name is also subject to certain legal protection. So that's sometimes cause the confusion, the trade name and the trademark. So have you met the same or similar situation in your country?
Yeah, I mean, with our system, they are interlinked. We have an organization or an institution called, the Companies and Intellectual Property Commission. So that's where companies and intellectual property matters are dealt with. Over and above that, we have domain name authorities, where if, for instance, and again it depends if you are focusing on a company that's a startup that has never done anything, that's looking into getting into a market, a particular market. As they register, they will have to register their company name. You will then have to advise them to also, protect, trademark their trademarks if there are any that are in existence. You would also, advise them to also register a domain name. So when you run a search, because most of the time you would have to run a search before you even go any further, before pumping money into something that you're not even sure if you will have rights over it in the future, to say we've run a search insofar as your trademark is concerned, proposed. We've run a search insofar as your company name is concerned, and this is what we are picking up. And as a result, we believe it's going to be a problem, or we don't think it's a problem. You can go ahead and file for protection. So it's highly unlikely, to find instances where, and I'm not saying it doesn't happen, where there is someone who is, owning a company that uses a particular name that is the same as a different somebody that's, that's owning a trademark that's similar to a company name that's sitting somewhere that doesn't belong to them. So it's highly unlikely to get into situations like that. But if it so happens, we have a system that sort of recognizes trademark, over and above what would be a company name. And again, questions of common law protection would have to be entertained about, use over time, who started using what, fair use, good faith, and all those considerations that would have to be made.
Yes. Any other questions from the audience? All right, thank you. So on behalf of IIPLA, we are happy to honor you. All right, now let's move to our next session, building an IP portfolio, strategies for startup and SMEs. For this, I would like to invite moderator Shashank Bhatia, managing partner of Tencom Intellectual Ventures from US. Joining him on the panel, Naveen from Logis